Hi there, this is Val Heminger, and I am the owner of Pathway Legal and one of its founders, along with our wonderful team. In this video, it's my most exciting video, I think, because I'm talking about avoiding court. Because guess what? You only want to use court as an absolute last resort for your family, rather than your first resort. We used to call it alternative dispute resolution, and I think in law schools they still call it alternative dispute resolution, or ADR. But here's the thing. Utilizing the many processes that can be available to you instead of the stress, expense, frustration, soul-sucking experience of going to court that are available, there's just so much out there for you. So let me talk about some of those options. One of those options that we use quite a bit as lawyers is called the four-way meeting. Now, since the pandemic hit, four-way meetings used to happen at a lawyer's office. Now they often happen by way of Zoom or another video conferencing format. Now, a four-way meeting is where you and your lawyer and a lawyer from another firm and your ex-spouse or soon-to-be ex-spouse sit down, roll up your sleeves, and come up with the agreement that you need to resolve your family matter in full. Now, I know that I will do that with most lawyers. There is the odd lawyer that I know that I don't want to waste your money or my time, because sometimes they're just too high conflict and too positional to be able to negotiate in an effective way to get you through to the other side of what you need to resolve. Your family plan in terms of what the parenting plan is, your financial situation, and dividing your assets. When I say that there's a few lawyers I won't work with, what I'd say is that it can often be a very cost-effective and powerful way to resolve your matter in a quick and inexpensive way. And in my experience, most lawyers, most family law lawyers with great experience are able to really assist their clients in this process. However, if your case is a little bit more high conflict, for example, maybe your spouse is not the kind of person who's going to be told by you or your lawyer about what the law is or anything like that. And make no mistake, when a person has their own lawyer, what that lawyer will do is tell them, for example, the bad news. Sometimes someone has to pay a certain amount of support and they can't believe that that could be possibly right. Well, it's better to come from their lawyer than you and your lawyer to give them that information. But when a matter's a little bit more high conflict, or we think that there's kind of more substantive issues that need to be determined, often what we do is mediation. Now, in a mediation process, you and your lawyer and your spouse and their lawyer are going to sit down together, and we're going to have a fifth person in the room. That fifth person is the mediator. Now, it's their job to get both sides talking to each other and to resolve the matter by having a full, formal, finalized agreement at the end. It's very powerful because in the mediation process, you can say whatever you want, you can make any kind of offer you want, and you don't have to worry about it being presented to the court later. We call that without prejudice discussions. Now, sometimes mediation doesn't work, and if it doesn't, then you can always go to court. Now, I want to get into what my favorite dispute resolution avenue is, and that is med-arb, or mediation arbitration. First of all, you choose a mediation arbitrator. Now, unlike mediation, you can compel somebody to go to mediation under the BC Supreme Court family rules. But in a med-arb, parties have to voluntarily sign up to that process. It's getting more and more popular, particularly after COVID. The parties enter into a med-arb agreement at the outset. So they first pick who that person is going to be. Both the lawyers say, yep, that would be the great mediation arbitrator. It's often a person who likely has experience in family law matters for forever and have the qualifications to not only be a mediator, but the qualifications to be an arbitrator. You enter into an agreement that says, hey, we're going to start with mediation, but if we don't finish this matter and we are unable to resolve, we're authorizing that mediator right now to take off their mediator, let's have an agreement hat, and put on their arbitrator arbitration hat, where they say, okay, this is going to be the decision if the parties can't agree. So what's so powerful about that is often when you go to mediation, sometimes they get hangry, or they're just like, they have fatigue from making so many decisions, and maybe it's the end of the day and then they lose their mind and then they don't end up with an agreement, or someone's just not being reasonable and nobody can convince them otherwise. Well, then the mediation would stop, and then We just have to, retool to go to court if the person wanted to have a final resolution. Now, it's very, very different with MEDAR, because at the end of the mediation, if there is no resolution, they don't have to down tools anymore. They would set it for another day most of the time, and they do the arbitration process, and they know they're going to come out of this situation with a binding decision. It's often much more financially reasonable to go through this process compared to court by a lot. It's a lot less stressful. I'm not saying it's not stressful. Getting separated and divorced is stressful, and yet, having said that, it's a way to get through it with your changing family mostly intact, in a way that they may not have been and will not have been if they went to court. I can almost promise you that. At Pathway Legal, we start with the dispute resolution mechanisms, and at the same time, it's super important, and sometimes lawyers do this, is they see that things are kind of conflicting out a bit, and they're like, oh my gosh, like let's hire a divorce coach and let's hire a financial planner, when really these parties only have, assets worth a couple $100,000, if that. Like, that's not necessarily a good use of resources if people don't have a lot. The best thing to do is to get them to a process that will see their matter resolved. So you want to start with the non-court process, but you don't want to spend days and days and meetings and letters racking up the costs without resolution. You want to be able to use a dispute resolution mechanism, get there. And, sometimes people say, okay, fine, we'll head to mediation. If that doesn't work, we're going to set it to court. If you are going to a lawyer-led mediation, that is, you have a lawyer, the other party has a lawyer, and then you have a professional mediator. In my experience, we settle the case probably 8 times out of 10. So compared to when you start a court application, how much less often that settles. And if you want to talk to a lawyer and need some legal advice, please contact us down here or give us a call, 250-220-8686. This is Val. Thanks for listening.